Ladies and gentlemen, I welcome all to my channel. We are seeing the series of videos under the head Do's and Don'ts in purchasing and selling the property. So far we have seen about 10 important aspects in purchasing and selling the property. And if you want to know the about certain aspect, you may watch the previous 10 videos. Today we are going to cover the 11th important aspect, which is very relevant in purchasing and selling the property, and it has a subtitle known as stop work notice, demolition notice and deoccupation notice. The previous three videos I have clearly discussed about what is meant by authorized construction or unauthorized construction. I have also distinguished between the two terms unauthorized construction and deviation. The authorized construction means the construction made after obtaining proper building approval from the development authorities. If any construction is made without proper planning approval from the development authority, such type of constructions are called unauthorized construction. Supposing a person obtained a building plan, but he has not constructed as per the has not put up construction as per the building plan and made some violations, deviation, then such type of construction are called deviation. So whenever unauthorized construction is made or whenever deviation is made, then the building owner may go for a regularization to get regularization or exemption from any enforcement action for demolition and such type of permission or approval from the government for exempting any rules is called regularization. All this aspect we have covered in the previous 3 or 4 videos. Now we are going to cover stop work notice, demolition notice and deoccupation notice. Supposing you are going to purchase a property and stop work notice or demolition notice or deoccupation notice are issued to that building, can you purchase that building? If you go and purchase that building, how to handle the situation? My humble advice is that it is not advisable to purchase such type of building, because if you go and approach the building, if you go and purchase the building, then you will have to face the legal consequences. Once the stop notice or demolition notice or deoccupation notice are issued, the government may at any time come and demolish the building. So you will have to face the consequences. So before, I just wanted to clarify what is meant by stop work notice and demolition notice and deoccupation notice. Supposing a person started to put up construction without planning approval, then the corporation authorities or municipal authorities or enforcement authorities or CMD authorities may come and ask the building owner to produce the approved building plan for the proposed construction. If the proper building approval was not produced before the inspection authorities, then they will issue a notice called stop work notice. In the stop work notice, they will direct the owner not to continue the construction work and to stop all construction works. So this is called stop work notice. Once the stop work notice is given and the building owner did not produce the proper building approval or planning permission, then the development authorities will come to a conclusion that the building is an unauthorized one. Then they will issue a demolition notice asking the building owner to demolish the building. So this is called demolition notice. If the demolition is not done within the stipulated period, then the development authorities will try to take further action to demolish the building with their own efforts. So for that thing, they will issue a notice called deoccupation notice. In the deoccupation notice, they will say that they will ask all the occupants, tenants, owners to vacate from the building and to hand over the possession, so that they will come and put up a seal, or they may also proceed further and demolish the building as per the government rules and regulations. So this type of notice is called deoccupation notice. So supposing you are a building owner and you receive any of the notice, what is the remedy available to you? The remedy available is that you have to make an appeal to the government under the Tamil Nadu Town and Country Planning Act, and you will have to get a stay from the government so that you can stop the development authorities from taking further demolition action. Unless you make a file an appeal before the government and get a stay, they may come and vacate the occupants from the building, and they may also seal the building, and they may also go to the extent of demolishing the building. So the first remedy available to the owners as against these three notices is to go and file an appeal before the government and to get a stay. By filing an appeal, you can prolong the proceedings and you can stop the government authorities from taking further action for demolition or deoccupation or for putting a seal for a considerable period of till the matter is decided by the government in the appeal. That is a revision. It is called also revision appeal. Supposing the division order is passed and order is dismissed as against you, then you may also have the another option to submit revised plan, and on the basis you can also file a petition before the concerned authorities or the court and ask the development authority not to take further action or not to take any demolition action till the revised approval is given, and you are given now, and as long as the revised plan is decided by the development authorities, concerned development authorities, or suppose if the concerned development authority rejected that revised plan, you can also file an appeal to the government and get a revised approval for the revised plan. Supposing the government law has also rejected that, you can also go to the High Court. So by filing a revised publication before the development authorities, or by filing a revision appeal to the government, or by filing a case in the High Court also, you can stop the government authorities from taking further action, and you can prolong the matter, and you can safeguard the building for a considerable period of time. Supposing your attempt to safeguard your building by a filing appeal or by revising plan is also did not give any fruitful result, then you may also go for a regularization. So regarding the regularization, where you have to file a regulation application, how you can to file a regulation application, what are the documents are required, are all discussed in the previous video that you can see in the previous video. So these are the three available remedies available to the owners of the property to safeguard the building as against the stop work notice, demolition notice, and deoccupation notice. So as far as the property purchase is concerned, it is not advisable to go and purchase the property for which any of these notices issued. If you go and purchase the property ignoring this notice, then you will have to face the consequences. The government may take further action at any time. They may come and steal the property, or they may come and demolish the property. That type of risks are always available on the properties for which these notices are issued. Supposing the property comes for a cheaper rate, supposing the building owner is asking only the price for the land, and they are ready to give the entire building for us free of cost, in that case you can purchase the property because you are not paying any price for the building. Or otherwise also, supposing the property is coming for a cheaper rate, you may purchase the property, but you will have to face the consequence, or the risk will always attach with this property as long as these notices have been issued and pending action actions are pending or proceedings are pending over the property. So if you are a owner or if you purchase a property with this notice, you can avail any of these remedies as discussed earlier to safeguard your interests and to safeguard a property as against the demolition action or as against the enforcement action in sealing the property. So this is the fact I want to convey through this video. So whenever the property has, whenever notices are issued to this property, it is not advisable to go and purchase a property. And if any notices are issued, you have to approach the concerned government appeal, you have to file an appeal, or you have to file a revised plan, or you have to get a regularization. That these are the remedies available in the court of under the Tamil Nadu Town Contemporary Planning Act. As against the orders, you can also approach the High Court for to stop the further action by filing appeals or by filing revisions or by filing High Court case or filing a revised plan or by filing revised application, regularization application. You can stop the enforcement authorities from taking necessary action, and you can also prolong the period, and you can safeguard the building for a particular period of time, and you can also save the building if you are able to get a proper order from the court or from the authorities. These are all the things I want to convey through this video. So you may, if you have any doubt, and you can clarify all your legal doubts through my channels. I have two large channels, Razak Law Tube and is an English channel, Razak Sattam is a Tamil channel. In addition to that, I also have a website, Google Sites, that's Ali Associate Chennai, and you can watch all my videos. There are a lot of playlists. You can click the relevant playlist, and you can click the relevant videos, and you can watch my videos through which you can clarify your doubts and enrich your legal knowledge. In addition to that, if you have any specific doubt or clarification, or if you need any consultation, you may also contact the cell number. If time so permits, I will try to give you proper consultation or advice or guidance depending upon my availability. So I will come again with another topic. Until then, goodbye. Razak Ali.